I'm going to turn the program over to Brittany Hendrix-Smith. Brittany's on the board of the Barristers, and she is going to take it from here. Thank you, Brittany.
Hello, happy Friday. So we are starting today with, can everyone hear me? Okay,
yes.
Good. Just making sure. All right, happy Friday. We're starting today with fundamentals of discovery. We have Rebecca Jones and Farah Hussein here to explain everything, so you'll know everything there is to know. Actually, yeah, you will not fundamentals, but so I think we're ready to get started. And if you do have questions, you could throw them in the chat, and also I'm sure we'll take questions at the end and go from there. All right, I'll turn it over.
Okay, thank you. So what we're going over today is discovery as it's governed by the Code of Civil Procedure. So anytime you see CCP, that's what we're referring to, Code of Civil Procedure. Section 2017.010 authorizes the discovery of any matter that's not privileged. So privileged information would be something along the lines of attorney-client communication, something with a medical provider that is not at issue in your matter, the basic privileges, that is relevant to the subject matter of the action or motion pending in the action, if the matter is itself admissible in evidence or appears to be reasonably calculated to lead to the discovery of admissible evidence. So anything that has some nexus to do with your case, some tangential relationship, that's going to be discoverable in your matter. And we go into first written discovery. Those tools include a request for production of documents, interrogatories, which are both special and form, and then requests for admissions and requests for genuineness. This is, again, all governed by the CCP. Everything we're going over today will be found in there. The request for production of documents is under Code of Civil Procedure 2031.020 and the following sections. It's useful when you're seeking documents to be produced by the opposing party. This is not going to extend to third parties. This particular tool is only going to be relevant within the matter and the parties themselves. So for example, in family law, when you have party A, and those are the two parties who are going to be under this rule. If you have a more complex civil matter where you may have does 1 through 10, you're talking about propounding discovery onto does 1 through 10. So anybody who's listed in those initial pleadings is going to be under this. It must be relevant to the matter. For example, you can't seek a criminal history in a pure financial dispute. You need to make sure, again, it's all tangentially related. If you have a family law matter that has to do with custody, maybe you can go into the criminal, but you probably can't go into something asking for extensive financial records if it's purely a custodial matter. It must be tailored to the relevant time frame. So if we're talking about a marriage that was 5 years, going back 20 years on records, it's going to exceed the reasonableness standard here. So you need to make sure that wherever you're looking at, it can be a little before, you might be able to go back 6 years on that 5-year marriage, but you want to make sure that everything is, again, related to the matter itself and doesn't go too broad, because as we'll discuss later, you're going to set yourself up to have an objection for an overbroad response when we get into that. There's no limit to the request for production of documents. There are limits on interrogatories and there are limits on requests for admissions. However, under the request for production of documents, you can have a 50 category request. I wouldn't recommend it. You're really going to make the other attorney mad, but you can do it if you so choose. And you also are not bound to any limit. You can do 5-6 sets of requests for production of documents. The only issue you would run into there is on your next set, you cannot ask for documents that you have already requested. So if you asked for bank statements from January 2010 to January 2020, in your next set, you can start from February 2020 forward, but you cannot ask for documents that you have already requested. A sample request might look something like this. This is getting into specifics. You want to make sure that everything is identified so you're not accused of being ambiguous or vague or not providing enough information to be able to answer the response. And you definitely don't want to be accused of being unintelligible. So any and all checking account records, including but not limited to registers, check stubs, canceled checks, bank statements, reconciliation statements. And then here we are with the period January 1st, 2021 until the date of production. You can request that time frame. You can end it earlier if you do not need anything close to the date of production, but typically going up to the date of production is a good stopping point. And then again, identifying specifically regarding any checking account, which has the respondent alone or in conjunction with someone else, which they may have the right to access to make withdrawals and write checks. So when you're doing this, it may appear a little compound, but as long as everything again is related to that original request, you want to be as detailed as possible. Going into interrogatories, there's two different types of interrogatories. We're dealing with special interrogatories, which are going to be specifically drafted by the attorney, and form interrogatories, which actually appear on judicial counsel forms. So the work is done there for you. Those are a great tool if you're kind of trying to get basic information to start off with. A special interrogatory is going to be specifically tailored to seek the relevant information to your matter, as opposed to the forms, which are going to be a little more general, but again, great starting off point if you're just trying to start collecting initial information. The special can ask that someone identify specific items such as accounts, dates and times, and events. It's limited to 35 interrogatories. There is an exception, however, where you can write a declaration, and we will send a copy of that around to the attendees after this. The sample declaration is covered under the CCP, and you just have to explain why 35 interrogatories is not sufficient, that you need additional information. It doesn't have to be very detailed. It's just required if you intend to go past the 35. As for form interrogatories, again, quick and easy way to start gathering specific details. You can pick a topic. You have general, you have employment law, unlawful detainer, limited civil, construction, family, and unlawful detainer. The most broad is going to be the general. That's an 8-page document. Personally, I tend to use the family law the most, but all of these are great resources in moving forward in your case. Form interrogatories do not count towards your limit on special interrogatories, and there's no limit to how often you can request those. It's just going to be an objection if you're requesting duplicative information. A sample interrogatory might look like identify each and every monthly expense which you are personally responsible for paying from January 1st, 2022 to present. So this is just asking for basically a list. It's one request, it's not compound, it's just asking for you to identify this specific category. The form, again, Judicial Council Form FL 145 for family law, Judicial Council Form DISC 001 for broader categories. That one, again, 8 pages, and it's going to ask for broader information such as witnesses, damages, medical history, things along those lines. And then we go into the request, which can be for admissions or for genuineness. Admissions is going to be governed under CCP 2033.001. It pins opposing party into an admit or deny. Those are the only options. You can't, there's no ability to explain yourself away here. It's did it happen or not? You have to be useful. It's useful if you're aware of specific items that you need the opposing party to specifically state are true or untrue. Again, if you know something to be true or untrue and you really just need them to admit it, this is the best tool to do so. This is again limited to 35 requests, but you can do the attorney declaration if you need more. Genuineness is covered under the same series under the CCP. It's used to authenticate documents. It's useful pre-trial in saving time for authentication rather than having someone identify the genuineness of a document on the stand. You can assert to the court, hey, this has been identified. We know that this is true and genuine, and move forward. Admissions, a sample would be admit or deny you were present at 123 Main Street on January 1st, 2022. You know the person was there, you just need them to admit it under oath. Genuineness, admit or deny the attached document is a true and correct copy of your bank statement from January 2022. Again, you know that this is true. You just need the person to go ahead and identify it for you. And with that, I'm going to go ahead and turn it over to Brittany for answering discovery.
Brittany, you are muted.
Well, guess I'll repeat that. All right, so answering discovery ends up, well, as you can imagine, being pretty dang important because one, you are giving up information that's theoretically going to be used against you in court. So that is going to obviously really take some decisions about especially answering more specific questions and explaining also to your client that these are the things that we need to be disclosing. So, but the other thing to think about is how you are answering your discovery specifically, like what information you're providing, the proof that you're giving up to the other side, et cetera. So I'm going to go through kind of what is discoverable, how the discovery is used, how you are supposed to answer, things like that. So you make sure you don't get back a meet and confer letter saying you didn't do X, Y, and Z. And if you don't get it to them in time, it leads to a motion to compel, which you definitely want to avoid if you can. So in general, information is discoverable in a discovery specific to your client if it's in your client's possession, custody, or control. Very narrowly, this isn't much. A lot of people say, oh, but I don't have that bank statement. Oh, but you have my insurance paperwork. That is, although it says that it needs to be in your possession, it doesn't need to actually be in your possession. So when it's in your custody and control is a factual issue that if it does get brought to a hearing would be a factual question for the court to decide. For example, a case previously heard in 2017 stated that if your attorney has it, that's in your possession and control. Same goes with an insurance company. It is in your possession and control if your insurance company is holding documents from you. This is often the case with bank statements, with things that are easily accessible to the other party. It's not just what do you have in your house today, it's what is in your control in the sense, do you have access to those documents? So it's definitely going to take a little more work than just going through the papers that you have, which especially these days is not a ton of papers since everything is electronic. So even if the request is for written responses, even if the request is for documents, you do have to serve a written response to each request. It needs to be within 30 days of the request, unless the specific date gives you some extra time if you have a really nice opposing counsel. But in general, as far as formatting the written response, the first paragraph of the response has to have the demanding party, the requesting party, and the set number, identifying that at the beginning. Keep things nice and organized and make sure you know what is being responded to. So in the body, make sure you identify each of the requests, like this document. Don't just give them a bunch of documents. You have to say, this is the document that is a response to this question. So going through each one of those things is really important, because if you just hand them a handful of stuff, there's no response. Verification is really important. Somehow, a lot of attorney signatures go on these things. A lot of unsigned responses go out. Those are basically like not getting an answer as far as the court's concerned. So you have to be getting these things signed by your client. And an exception to that is if you only have objections, if your entire response is an objection, or any individual line is just an objection and you're not providing any actual information, those specific things can be signed off on by the attorney. But if you have, 1 through 8 and all of them are objections except for number 7, you need to go through each of the individual ones and sign off as the attorney, and you're still going to need that client sign off on the one that actually has a response. Next slide. Who's in charge? Just kidding. All right. So each of the different kinds of discovery have different requirements as to answers. And I made a code kind of cheat sheet. So hopefully it will be easy for you to find where all that information is. The thing about discovery is it has pretty clear rules. Like you want to know what the rules are. And if you can just go through each one of the things that's in the code. When I first started learning discovery, I just went and read the whole CCP, went through the rules of court, read some case law that seemed a little more popular, and really tried to get a good grasp on it from the get-go. That has been, I know you're in this MCLE, but really is, if you want to be good at and you want to be specific and you want to be able to call out the other side on if they're, giving you a bunch of crap for something, it is honestly, it is invaluable just to go through. So for request for production, this can also be a request for inspection. It can be a request to, have access to something, but it's more tangible things. And request to copy something. You can request to go to someone's office and look through their file cabinet. You can request lots of things. Of course, within reason, has to not be objectionable based on relevance or some of the grounds. But in your request of production, like I said, you can't just hand them a bunch of paperwork. You have to actually go through each individual number and answer the questions. So there's three things, three kind of options as far as the statement that you give them back. So it'll say, request number one was provide all your bank statements from January to December. Then your answer can't just be like a piece of paper saying, here's the bank statement. You have to go through each one and either say that you're going to comply, that you can't comply, or that you object. So three different options here. A statement that you will comply. You also have to say that these are all the things in my possession, custody, and control, and they're provided. If you don't include that these are all the things, they may object and say, you haven't given a definitive statement that you don't have anything else. Just because you gave us what you did give us doesn't mean that nothing else is in your possession. So you have to make a clear statement that everything I have is here. For the lack of ability to comply, this is always a good one. If you're like, well, how on earth would I do that? Something that never existed, perhaps. Hey, give me your closing statement from this mansion that you bought. Okay, well, can't do that. And it's not because I object to the request per se, but it's because, a mansion. So you got to go through each one of those things directly and say, look, I can't comply, but you also have to give the reason you can't comply. It's been destroyed, it's been lost, it never existed, I've never had it in my possession. And then you have to identify who might have it. Obviously not the other example, but if you say, hey, I think my brother Joe's the one who's holding on to my grandpa's will, you got to give him that guy's information so they can go get it from him. If you're objecting, this one kind of goes through there's always objections, right? So an objection, you can't just object. You got to identify the grounds. You could say it's outside the scope, but really what you're looking at as far as an objection where you're actually not providing information is going to be privilege. That includes all the kinds of privilege. So you have your clergy relationships, you have your doctor relationships, your therapist, your attorney. And definitely make sure that if you are objecting on a privilege grounds, you make that assertion at the beginning, because if you do provide something that would otherwise be privileged, you can be considered to have waived that privilege. And then they can expand upon their requests based around that information, because you already waived your right to assert it. And once you waive your right, you can't get it back. So one of the things that I kind of learned as far as formatting, go back, but as far as formatting, an important one is if you can't get something by the due date, which my God is like half my life, you can object as to the date. You could say, hey, I'm getting this from the bank, so I object specifically on the grounds that I can't get it to you by the 30th. So you can provide that in your answer. So you don't have to say in your answer, like, I don't have it. You know, you just say objection based on the date set. I would require an extension. Okay, now you can go. So requests for admissions. Okay, I think these are severely underused, and especially the requests for genuineness of documents, which is like my very favorite thing if you even think you're going to trial. So a request for admissions, there is a form that you can use to ask for the request for admissions to start. That's DISC 020. And what's great is that it just lets you click a few boxes and get that out. But then you also have to, when you're answering, there's a little bit of nuance that you can use to try and avoid any admissions that you may not want to make. So the big thing about admissions is the answers have to be straightforward and simple on pretty much all of these, because you can admit an answer. You can say, I admit part of the answer is true, but not another part. So there is a partial admission. You could say, hey, do you agree that you were 18 on this date when the bus hit you? And you could say, well, I agree that on that date the bus hit me, but I don't agree that I was 18. So you can have the partial admission and explain in there the parts where you agree and disagree. Sometimes people will just say deny when it's all because the entirety of the statement is not true. You can also kind of do that, but you really, the thing is when you kind of try and play games with like, oh, deny, you're just going to end up with another batch of admissions from that person asking you again, which honestly, you know, just kind of getting that straightforward answer, just when you can be helpful, just be helpful, because there's plenty of things that you can argue about and win on that are not technicalities where you're making another side redistribute their discovery. You can answer that you lack specific knowledge, but be sure that if you're saying you lack specific knowledge, the same as with the custody and control, you have to go and say what you did to try and get that knowledge. Admit that you have this bank account number. Okay, I went to the bank and I checked with them in my records and they said that I didn't have that. That's something that you can admit or deny. But if you say, oh, I don't have enough information because the bank's the only one who knows because I lost the records, that's not enough. You have to go get that information. So when your client said, well, I don't know. Okay, well, time for you to go find out. There's a lot of work for you. Give your clients lots of homework and tell them that they need to, if it's important to them, which I assume it is because they're paying you to do it, they need to put in the work to do it. You can deny answers. You can be very straightforward, but be careful with denials, because if you are found to be lying about your denial, you can be liable for costs and fees. This is a really big one that I have used with requests for genuineness of documents. It really helps if you are trying to get documents in that would otherwise need to be authenticated by some random person that you really are not looking to subpoena, some kind of like a child's school record or something. Technically, do you need to drag the school in to authenticate the records? Yeah, you might need to, but if you do this, it's something they've both seen. They're going to really have to say, do you admit that this document is the one you got from the school? Do you admit that this is a true document? They will be pretty much forced into it. And if they deny it and say, oh, well, I don't know that it's genuine, they could be on the hook if it's found to be genuine later on, based on their lack of participation. So, and another thing there is if you are using it for genuineness of documents, make sure you're admitting that the document itself is genuine. You're not admitting or denying that the information in the document is legitimate. So if you're saying, oh, I got this letter from a doctor saying, oh, she can't work for the next 6 months. You're not admitting that that is a factual conclusion that they can't work for 6 months. You're admitting that that is the note from the doctor. And your job then would be to cross-examine the doctor, not necessarily to argue the genuineness of the document itself. All right. Oh, and objections, same thing. Next, please. And then finally, interrogatories, the ones with the most art, because really it's just the information you're giving. They say that you have to tell the truth, the whole truth, and nothing but the truth was the case law on that, which, you know, is dramatic. But answers can't be evasive. Like I said, you don't want to try to trick them because of how they requested the information. Say, oh, well, you only asked for this little thing. Just give them what you have. What I keep finding time and time again is that every time I try and be like, oh, well, that would be sneaky and any sort of gotcha moment, it's not worth it. It is, you probably won't even get it in half the time. And really just being upfront at the beginning is a more relaxing and holistic way to practice law. So you do, once again, have to make a good faith effort to obtain the information. You have the obligation to talk to people. You can't just say you don't know. You got to go get the information. All right. Back to Becky.
Okay, so there's three paths basically that can come next. So you have your discovery issued. You may get I say may get, it never happens. A response answered with no issues. Again, great, that happens to you. You have the unicorn. There's usually some issue where you need to issue a meet and confer letter to go over anything that might be missing or underrepresented. The most common is a response with deficiencies. Somebody's made a good faith effort to comply for whatever reason, it's missing information. So then you have to do a meet and confer letter. There's a 45-day timeline. It's governed under several different statutes within the CCP. This 45-day timeline is from the date you get back the responses. Within 45 days, you must do the meet and confer letter, see if they give you a supplemental response, and then file the motion to compel if necessary. That you can mutually extend this. Quite often, I've done this with counsel where you have a good relationship and you're explaining back and forth, hey, I'm just having trouble getting the documents. My client can't find them. Okay, fine. We're going to do a mutual extension by 30 days. So now I have 75 days in which to file my motion to compel, and you have an extra 30 days in which to get me the responses. That's fine. Just make sure it's in writing by agreement. Doing it over the phone is not going to hold up in court if something falls apart. If there is no response, you still have to do a meet and confer letter. However, it is way simpler. You basically send the letter saying, hey, you didn't send me anything. You have to send me everything. And you've now waived all of your objections. All objections are waived if you do not raise them within the 30-day timeline that you were initially given to respond. Again, your responses, your initial set of responses can be extended out by mutual agreement. I often do that. I very rarely receive a response back within the first 30 days. It's very common practice to ask for an additional 2 weeks, 30 days, depending on what's going on. Attorneys are busy. We all know this. Sometimes it's difficult for us to take the time to get into these in-depth responses. So the extensions happen all the time. It's good faith. It's good practice, in my opinion, to go ahead and do that. The meet and confer letter. It is a declaration in support of a motion stating the facts, showing a reasonable and good faith attempt to an informal resolution without involving the court. So again, you're sending the letter over saying, hey, these documents are missing. Please get them over to me so I do not have to file a motion to compel further responses. Identification, you're going to state the tools that were propounded. So this was my request for production of documents, and it was issued on January 5th. Due to me February 5th, and your response came to me on February 5th. Okay, so here's all the information identifying. Always write the meet and confer letter, assuming it's going to be an exhibit to go to the court. I always write mine so that I can attach it to a pleading so the court can see I made every effort to try and resolve this before coming to the point where we're incurring a lot of attorney's fees preparing for a motion to compel. You need to specifically identify the deficiencies. So you sent me bank statements for this range. However, you didn't send it to me for the rest of what I requested. Identify very specifically what you received and what you did not receive. It could have been a simple error, what they sent the second batch, and they just didn't. So they need to get it over to you. So make sure it's very clear. Here is what I have. Here is what I do not. The applicability of objections. So if there's an objection that makes no sense, you can ask for it to be withdrawn. So say somebody objects in a financial matter, you've asked for a year's worth of bank statements and they say, no, you don't get to know my income. You don't get to know what's in my bank statements. Well, yes, you do. It is relevant. They object on relevance grounds. It's completely relevant to what you're talking about. So you can ask that that objection be removed. It's technically an abuse of the discovery process to raise objections that are not applicable to the proceedings. Again, the waiver of objections. So if they failed to respond at all, then you have completely waived your ability to raise the objections in the future. I've had that come up where the deadline got blown. I said, you owe me the responses, and then they send me a bunch of objections, and I've had to send another meet and confer letter saying, you don't get to object to anything. You have to send me everything I initially requested for. We're past that point. The deadline, again, it's the 45 days. So you have to issue the meet and confer and file the motion to compel unless there's a mutual extension. You have to do the meet and confer to be in compliance with the CCP requirements to file the motion to compel. You cannot file a motion to compel without the good faith effort to meet and confer. Supplemental responses, again, they
Rebecca,
need.
we have one question about objections in the chat. So I'm just gonna read it out loud so that the other.
Please do. I cannot get to the chat while I'm sharing screen, so that's helpful. Thank you.
Yeah, so one of our participants asks, did I hear correctly that you have to raise your objection within the first 30 days when your initial responses are due, regardless if there is a mutual agreement for extension?
So if you're extending the response time, then you're also extending the objection time. When I say the first 30 days, that's assuming that somebody's going to answer within 30 days. If we all agree, hey, they're not going to be due for 60 days, you just have to raise it within that timeline that has been set out. So if I'm saying everything's due to me on November 7th, and you plan to respond by November 7th, the objection needs to be within that period. If we agree, hey, you have an extension till December 7th, now you have this new period in which to raise the objections. Okay, thank you. So for the supplemental responses, identify the propounding, demanding, and requesting parties. So you need to identify who is, who sent the request, who is answering the request. That you need to explain which set number this is. So if you've done multiple requests for production of documents, be sure to identify this is in response to request for production of documents number 3. And each response must be identified by the same number or letter, and it must be in the same sequence as the request. So when you do your responses, you can't jump around and say, okay, well, it's easy for me to answer number 14, so I'm going to put that first. Everything needs to correspond. So answer 1 needs to correspond to whatever request 1 was, and so forth. Same for the supplemental responses. When I'm doing supplemental responses, because we all end up with meet and confer letters, we all have to respond with more information. I'll say, here was the initial request, here's what my initial response was, and now here's my new supplemental response, so that there is a tracking of where we are in receiving the information. And then finally, there's the motion to compel. There's a motion to compel a response when there's been no information provided at all. A motion to compel further responses when it is completely deficient, and a motion to compel compliance in accordance with the prior response, which is no deadline. So if there's an agreement that things need to be turned over and they have not been, now you're in the motion to compel compliance phase. Filing the motion to compel requires the original demand, the original answer, a proposed order, and a proof of service. These are bulky. When you're expecting to file these are going to be a very, very large stack of papers that are going to the court, because you need the court to understand everything that's occurred. Since discovery is not something that the court often sees themselves, you have to give the entire background. It's not going to be in their file. They are not going to know what's going on in your situation. Specific facts setting forth the good cause justifying the discovery. So if somebody is saying they do not have access to something, you need to present why you know they have access. For example, you can see on somebody's bank statement that they have deposits coming in from Venmo, and they're telling you, oh, I don't have access to that Venmo account. Clearly you do, because it's your Venmo account putting deposits into your bank accounts. So that would be something that you would present to the court to say, this is the only way I'm going to be able to get this information. This person is not being honest about their access. A meet and confer declaration. So that's, again, going through explaining to the court, here's every effort I have made to try to resolve this. I do not want to come to the court. This is costly. Courts don't particularly like motion to compels, because it means somewhere along the lines, there's been a breakdown on the communication between the attorneys in something that should be very simple to be done. If you have the document, you need to turn it over. That's pretty much all it is. Somebody is not being genuine if you've gotten to the point of a motion to compel. And finally, you need the separate statement. This is not required where there's been no response, but the separate statement is going to lay out essentially what was already in your meet and confer letter. So here's the category, here's what's missing, here's what you've provided. The separate statement will also explain why you know this party has it. So again, looking at this bank statement, I know only you have access to this Venmo account. Okay, and I went a little too early there. So text of the request, interrogatory question, or inspection demand, the text of each response, answer, or objection, a statement of the factual and legal reasons for compelling further responses, if necessary, the text of all the definitions, instructions, and other matters. So there's usually a preamble included in all of your discovery requests where you explain, this is what I mean when I say document. When I say you, I'm referring to respondent or the responding party. You may need to include that for the court if it's not clear on its face what your original request was. And finally, if the response to a particular discovery request is dependent on the response given to another discovery request. So, for example, admit that you lived at 123 Main Street from February to May 2022. Okay, so if you admit you did, if your answer to this interrogatory was admit that you lived with such and such a party. So if they're going to be dependent and building off of each other, you may need to refer back to what the initial request was that you're referring to. And like I said, the separate statement is your meet and confer letter, basically. So just be prepared to have that information ready to go. It may feel like a lot early on when you're doing the letter, but it is very useful once you get to that motion to compel points. And with that, we are going to turn it over to Farah.
All right, thank you, everyone. I'm here to talk about depositions. I think depositions are one of the more fun discovery tools that we have. As a practical matter, I like to issue deposition notices after I have gotten some written discovery. I find that it's more productive that way. However, the rules say you can do it within 10 days. So you can serve someone and set their depo right after that. As a practical matter, you set yourself up for a better deposition when you've had the opportunity to have a round or two of discovery and able to take deeper dives on deeper topics. So I'm here to tell you about the do's and don'ts. I've been doing civil on and off for a little over 7 years. I've taken somewhere in the ballpark of 50 depots and defended somewhere in the ballpark of 50 to 75. As a city attorney in Vallejo, we have a lot of litigation. So I've seen a lot of things that are done well and things that could definitely use some improvement. It might sound obvious, but especially those of us who have a criminal background, I think that we have the attitude of, give me 12 people in a box. I just want my trial. I just want my day in court. In civil, it's much different. Your goal should be to win on a motion for summary judgment. If you're the defense, obviously you're trying to pare things down at the motion to dismiss stage or demur in state court. But we really want to be thinking about the motion for summary judgment, and that should be driving our deposition outlines. And so what we mean by that, if you are bringing the action, then you're going to want to have those KC jury instructions out, and you're going to want to look for everything that you have to prove and organize your outline accordingly. So in a little bit, we'll talk about background questions that we ask, and then, in terms of how to approach a depo. I think a efficient and tried and true strategy is to start with some initial background questions, get into the elements of the case, what you have to prove, asking paring down questions around those KC jury instructions, any affirmative defenses, if you're the defense. And then the last portion of the outline is really asking discovery related questions in the deposition. Something that we don't see often. I think it's an underutilized tool, but we have some slides later on to talk about that. But really be thinking about the motion for summary judgment when you are outlining a deposition. Also, be thinking about witness unavailability. Sometimes the deposition, we're married to these transcripts. Once somebody gives testimony, that's it. And so if for whatever reason they become unavailable, whether it's pre-planned travel or death, or they move out of the country, or whatever unpredictable circumstance will happen when you're in trial, the transcript might be what you're stuck with. And so you want to make sure that you're thinking about what this transcript looks like and slowing things down. And if you're defending the deposition, cleaning up some portions at the end. I've certainly made the mistake of not asking questions at the end, thinking, oh, if worse comes to worse, he can just explain this on the stand. And then that person was unavailable for trial. And I'm stuck with what this transcript looks like, even though I know it's not the full story and I know it's not the truth. So you want to be very mindful of these trial related issues as you're conducting your discovery. Most clients are woefully, I don't say underprepared, but prepping your client for a deposition is an art. For me, it takes a half day minimum. There's just so much to go over. Everyone should really develop a checklist of, oh, I'm sorry, we're still on the previous slide. Becky, I apologize. Yeah, so prepping your client. So you want to tell them everything. They're new to this. I think because we live in our world, we sort of see the formalities of things. I represent a lot of people from public works, and they wear their safety vests and sometimes show their tattoos or have piercings, and it's a video depo or a fun colored hair color. And while that's perfectly fine when they're out there doing their job, we're always worried about the formalities of court. So I like to create a checklist that, I'm talking to a smart fifth grader, right? I go over everything from your appearance, what to expect. If I make an objection, what that means. We're talking in code a little bit there. If I make a certain objection, that should mean something to you, having that discussion. And just being really mindful of, especially in a case like family law or cases that are just really, the emotional temperature has been raised, body language, facial expressions. It can be really hard to account for those things. So we want to have some practice sessions in our depo prep so that they can have a better understanding of what the day will look like. But I highly suggest creating some kind of checklist to prep your client and have it be as over-encompassing as possible, because again, you are married to this transcript. That is all you're going to have for the rest of your case. It's very difficult to come back and get additional depo testimony. So we want to be really cautious and mindful that to spend time to prepare them well. We want to make sure to, so when you're, obviously know the facts of your case. I've had opposing counsels get their facts confused, especially, we have some people who sue the city for a bunch of dangerous conditions and they show up and they're forgetting which one this is. You don't want to be that person, right? Take a few moments before the depo, get organized, make sure, you're here for the case you think you're here for. You have a really well prepped outline, all of those things. So witness admonitions. So at the beginning of a deposition, you're always going to want to ask the other side if their deposition has been taken before. If it hasn't, you're going to want to go over the ground rules with them. So that's if you're taking the deposition, and if you're prepping your client, same thing. You want to go over the ground rules with them. So you'll, tell them that the oath is the same. There's no judge here. We're going to be making objections for the record. We have to talk in a very unnatural, slowed down way because we're making a record and the court reporter needs to write these things down. If you need a break, feel free to ask for one. What I like to do is take a break at every 50 minutes. So I'll go for 50 minutes and then take a 10-minute break. That sort of allows for people to rest, use the bathroom, and the court reporter, resting their hands and things like that. So I make an announcement at the beginning of the deposition to set that schedule so people can know what's going on that day. So you'll want to go over the ground rules with them. You'll also want to ask about discovery. So, a lot of times when cases go out, we send out litigation holds. You'll want to ask them, did you get this? Have you seen this request for production before? How did you look for these? When you saw it, what did you do? How did you look? How long did you look for? Did you check your computer? Did you check your phone? Did you check all of your mobile devices? Is the stuff backed up to the cloud? Did you check there? The courts place a pretty high expectation for us to know where all of our things live in this very tech savvy world. So you'll want to ask those specific questions. And a lot of times you'll be surprised what people say. They might not have done as thorough as a search as one would have expected. And you don't want to be that lawyer who's surprised on the flip side. So make sure when you tell your clients to go look for stuff that you're telling them to truly look in all of the places, because that's never a fun moment in deposition. When we do that's another reason I like to propound documents before issuing a depo, is that when you have the documents that you got in discovery, you can ask more questions about them, and then you can attach them as an exhibit to the deposition transcript. So then later when you're bringing, motions, that's already built into the discovery process. So, and then that goes into the prep, right? You're going to want to think about doing it in an organized way so that this transcript makes sense when you're fishing for those portions of the deposition transcript for your motion. Making code compliant objections. So there aren't very many. There's a very short list of code compliant objections and ones that aren't. And we'll talk a little bit about that. And then obviously, just finding your style. So you're going to want to, do what feels comfortable, practice. A lot of times I will make an outline, read things out loud, see if it feels right and organized. But you're going to want to find the right tone, and you'll take a different approach with different witnesses. Some might be a little more adversarial and some might be more friendly, but you want to make sure that you are being true to yourself so that you can do your best work. Next slide, please. So here's a list of code compliant objections. I will briefly mention them. So stating a legal conclusion, something that calls for speculation, a narrative, a compound question. Again, we can't, where it's all about the clarity of the transcript. So if you ask a question that calls for two answers, that's not going to produce a clear transcript. And usually counsel's pretty good about agreeing that it'll be compound and separating it. Harassing, an incomplete hypothetical, vague, leading, and unintelligible. So more often than not, when you are making an objection, you're just making it for the record. If you feel so strongly about an objection that your client should not have to answer, you can instruct them not to answer and state the basis. However, if they drag you to court and you're wrong, you have to pay for all the costs associated with that and for them to come back and take that deposition. So be cautious about instructing clients not to answer based on any objection or privilege that we'll talk about in a little bit, because it's pretty high stakes and you don't want to be wrong. And as a general matter, civil discovery is pretty open, right? It's allowed as long as it's likely to lead to reasonably discoverable evidence. So it's pretty rare. These are non-code compliant objections that we unfortunately see all the time. So again, relevance is a hard one just because the nature of discovery is pretty broad. Hearsay, asked and answered, any speaking objections. And when I find that a opposing counsel of mine is making a lot of speaking objections, I will just ask to go off the record and then have a conversation with them about it. No, you're paying for this transcript. I'm not certainly going to sit here and pay for someone else to hear themselves talk. So I will remind them off the record that, speaking objections are not allowed. Please keep your objections to the code. However, if you want to flag certain parts of this transcript for us to meet and confer about later, that's fine. So I'm not one to have heated arguments on the record. I don't think it's productive. I like to go off the record and have those discussions, come back, put the pertinent things on the record so that if you need to bring any motions, it's still preserved, and continue on. But when the lawyers start arguing mid-deposition back and forth, it's uncomfortable for everyone. It's not code compliant. It's not how things are supposed to go. So I found that strategy is pretty helpful. So Brittany talked to us a little bit about privileges, and you can instruct not to answer on the basis of privileges. And in California, we have quite a few. A lot of them are going to be the ones you think. So sexual assault counselor, human trafficking caseworker, DV, all the ones we learned about in law school, attorney-client, marriage, doctor-patient. There's one for therapist-patient now. And then all of those criminal law ones that we also learn about too. If you have a criminal case, if answering the question would incriminate oneself. And then there's also an official information privilege, which mainly just applies to the way that police officers learn information. But that would be a privilege you assert to instruct, not to answer. Another deposition don't. So going back to your style, don't be a bully and don't be bullied. And I think it's hard to, sometimes if you're really passionate, it's hard to be mindful of if you're being a bully, right? Everyone wants to zealously advocate for their clients. Nobody wants to be the bully. And it's also really uncomfortable when you're on the receiving end because you want to also represent your client well, but sometimes all you can kind of do is just make objections. And so you'll find your way. And again, some tools are just to take moments to pause, go off of the record, set the tone. Some people will object if they're defending depositions early on, just to kind of communicate to the other side, hey, I'm not, I'm not just going to sit here and be passive. So you'll find what works, but everyone always, wants to be a professional. It's really hard to not talk over the witness or the court reporter, especially in Zoom depots. It can be a little tricky, but again, remember, we just have one transcript. We want to make sure that we're going slow and that the record, is what we are paying all this money for it to be. Usable. Recognize when to stop. So I've made this mistake and I've seen this a couple times with attorneys. Sometimes you'll ask a question and you'll get a golden piece of information. You'll get this nugget and it'll be so fantastic. And then you'll ask a follow-up question and that person will immediately explain away the golden nugget that you just got. So recognizing when to stop, again, thinking about the record, right? Does it say what I need it to say? Move on. A lot of times those lawyers, I think, we want to dig for more or really, really over clarify. So be mindful of that. If you've gotten yourself a golden nugget, just keep it moving, because the more you bring attention to it, the more the other side will realize, oh, hey, this is what I really meant, or this is what I was trying to say, things like that. Also, don't ever threaten to call the judge mid-deposition. That's just like a fake threat that people do on TV, and I've never seen that work out for anyone in real life. Much like our co-presenter said, if you have an issue, then you put it on the record and you will bring the appropriate motion. But no judge wants to be called in the middle of your deposition. Depo subpoenas. So production of documents. So you can have someone bring documents with them to the deposition. The CCP code section that mentions this is 1985.3 and 2020.410. I know we have a hard stop at 1, so I won't read them to you. But essentially, when you issue a deposition notice, you can make them bring things with them. And those sections cover how that is to be done. And there's also something called a notice to consumer. So if you subpoena medical records or you subpoena business records, I'm sorry, the hard stop is at 1:15, thank you. Then you have to do something called a notice to consumer, which means the other side has the ability to object to what is being propounded. So they can file the appropriate motion, and then you can go to court and fight about it. But the propounding party has this obligation to comply with the notice. The failure to do so makes it dead on arrival. So you want to note this section really well. It's a common mistake, but just think about mainly in medical records and mainly in business records. And again, for people who sue the city, for example, for dangerous condition, they tripped and fell and they want to show us how bad their injuries are. If you put your medical records at issue, you then can't come back and say, oh, hey, you can't dig into my medical records. So, but you just as the propounding party have to comply and let them know, hey, I issued this subpoena. You have 10 days to let us know if you have any issues with that. I think we have a question in the chat. I will read it out loud. What are the options for compliance if the deponent does not bring all the documents listed on attachment 3 of the subpoena? So it would essentially be the equivalent of a motion to compel. I haven't had straight up, I've had non-compliance, but it's been for a good reason. Like someone will come and they'll say, oh, the way that my company switched programs for how we keep these documents, and I need to go back and figure out how to get access, and I just need a little bit more time to do that. So those are usually the kinds of issues I've seen when someone comes to a depot notice and didn't bring the things with them that they were supposed to bring. If it's just a straight up refusal, you would do that motion to compel process that Becky and Brittany talked about earlier. It's pretty bold and hard to defend. So for those reasons, it's pretty rare. So what questions do you have for us?
I have a follow-up to that, Farah. For those of us that practice family law and we are deposing pro pers, it is very common that they don't bring the documents. Just as an aside, you have to remember that some of us, we don't always get to deal with attorneys. Sometimes we have to depose pro pers, which is very difficult.
Yeah, I have no family law experience. So I mainly do civil and I did a little bit of criminal. So that is a really good point. If you're dealing with a pro per person, then, it's even more considerations. You're going to want to make sure that you make a record, that you were very clear, that you're showing the judge you tried to help them. You're always going to want to come to court setting that I did everything I could before I got you involved, judge. And now I have no other choice but to ask for your help. That's what you're going for. Especially when it's a pro per, because they're going to look to you and say, oh, hey, did you tell them what they needed to do? And they don't. So from an equity standpoint, they tend to put a little bit of more of that education burden on us when you do have a pro per.
Oh, yes.
Yeah. And that can be tricky. You're here to represent your client. So.
Okay, does anybody have any?
I think.
Oh, yeah.
Any
Go
other
ahead.
questions? I was just going to say, I don't think there's any in the chat, but are there any questions from anyone that we may have some insight on?
I'm going to put my contact information in the chat. I know there's a lot of information, but I highly suggest, especially for depositions, sitting in on a few, watching someone take a deposition and watching defend. I work for the city of Vallejo. We have multiple depositions every week, if not month. I can always ask for permission to someone to sit in to watch, especially if it's done remotely. But I think that's the best way to learn. Watch someone do it and have a little debriefing conference afterwards, because that's where you really learn. Reading the rules is a good place to start. I can't believe how many times someone's told me something and I've had to cite the rules to them. So start there. But to gain that practical experience, I think just asking to shadow someone when they take and defend a depot is the best way.
I think that sounds like the next great program. You guys do a mock deposition.
Now I'm an actor.
I'll be a witness. You guys, somebody can depose me. I promise to be good and bad.
You'll be too hard to prep.
I will mention that I think there's a new rule in California that says when we produce Discovery 2 for requests for production of documents, we have to bait stamp them, and we also have to bait stamp them if we mention that answer in a special interrogatory. So for example, if your answer to a special interrogatory mentions where the documents would be, because usually you get all these at once. You get requests for form rogs and special rogs and requests for production of documents at once. And so I believe that there's a new rule that says not only do we have to bait stamp them, but if one of your other sets of discovery mentions it, you have to provide the specific number. You can't just like turn over a stack of things anymore. So, so that's a change that I think is worth taking note of.
Helpful change, yeah.
Do they still call it bait stamping or not numbering?
It's bait stamps.
I think, I just click a few buttons on Adobe and it slaps the numbers on there for me.
Right,
so.
right. No, I know, but you guys, I mean, I don't know if you guys are old enough to know that there used to be an actual thing that went like this, and the numbers change, and the name of it was a BATES stamp. It was a big, like you would stamp a, copy or something like that, but it was a big metal thing and the numbers moved. So, and that's what it's called, the bait stamp. And since you do little stickers or automatic numbering now, I thought they just called it numbering documents, but that you referred to it as bait stamping.
Hanging in there.
What it is, nothing changed there.
I just dated myself big time. Okay.
Oh, so it's good to know why something's named the way it is. So I wouldn't put my email in the chat. Don't be shy. I watched a bunch of depots before I took my first one. I looked at many sets of discovery before I propounded my first ones. Ask around. We're here to help.
Yeah, I threw mine in just in case, and I'm sure Rebecca will too.
Yeah.
And if you do have any questions, honestly, one of the biggest things is just asking someone, because we've all had stupid questions that we didn't, or felt like stupid questions that we didn't know the answer to at some point. And just having someone who will just help you is really like huge. To have someone who will just be like, oh yeah, hey, there's this thing that you have to do, or oh, that's how you fix that, is really valuable. So reach out to people.
And you guys have your group Vine for that as well. So you can do I know the solo section makes incredible use of their group Vine for just such things like that. Like, I've got to do a blah. How do I do it in this chord or this chord or that, so that's another good way to do that. Okay.
All right,
Any
guys.
more
Well,
questions?
thanks
from
for being here on a Friday.
All right, any questions, just let us know. Thanks, guys.
And somebody will get me the let's see.
Yeah, I'm gonna